Greetings, everyone. By now, we know that three organizations approached the Gauteng High Court in Pretoria on behalf of holders of the Zimbabwe exemption permits. We have discussed the Helen Suzman and others court judgment. We promised that we'll discuss the Zimbabwe Immigration Federation court judgment. We have not yet received the judgment of the African amenities as represented by Advocate Simba Chitando. Once we get the judgment, we will discuss it as well. So what we are going to do in this video, we will, first part is to talk about those that brought the application or who approached the courts. That is the applicants and the respondent. The second part, why they approached the court. And then in the last part, which is the third part, the court order. We are not going to discuss the entire 35-page judgment. So in the matter between Vinderen Manganzire, first applicant, Zimbabwe Immigration Federation, second applicant, and the Minister of Home Affairs, first respondent, Director General, Department of Home Affairs, second respondent, Minister of Police, third respondent, National Commission of the South African Police Service, fourth respondent, President of the Republic of South Africa, fifth respondent, the Border Management Authority, sixth respondent, the South African National Defence Force, seventh respondent. The court, in terms of the introduction, I will skip part 1. Part 2 says, before this court is an application under part A for an interim interdict pending the review relief sought under part B. As per their notice of motion, the applicants seek the following: an order interdicting and restraining the respondents from arresting, issuing an order for deportation or detaining any holder of the Zimbabwe exemption permit for the purposes of deportation in terms of Section 34 of the Immigration Act 13 of 2002 for any reason related to him or her not having any valid exemption certificate in his or her passport. An order directing that any holder of ZEP may not be dealt with in terms of sections 29, 30, and 32 of the Immigration Act, solely for the reasons that they are a holder of the Zimbabwe exemption permit, and an order directing that the holder of the ZEP may be allowed to enter into or depart from the Republic of South Africa in terms of Section 9 of the Act, read together with the Immigration Regulations 2014, provided that he or she complies with all other requirements for entry into and departure from the Republic, save for the reasons of not having a valid permit indicated in his or her passport. The main application under Part B is brought in terms of Rule 53 of the Uniform Rules of Court. Even though this court is not seized with Part B, it must take a judicial peek into the grounds of review which are raised in the main application and assess the strengths. I will skip the rest because by now we understand why they approached the court. They did not approach the court for the extension in this judgment which I'm reading, but seeking the court that the holders of Zimbabwe exemption permit should not be arrested. I don't have in front of me the main application as indicated in this judgment, so I have no content in terms of what the main application is. Let's get to the order of this judgment. The order says, pending the judgment of this court in the main application. As I've already said, that I do not have access to the main application, so I do not know what the main application is, but it says, the order says, pending the judgment of this court in the main application under B, the respondents are A, interdicted and restrained from arresting, issuing an order for deportation or detaining any holder of the Zimbabwe exemption permit for the purposes of deportation in terms of Section 34 of the Immigration Act 13 of 2002 for any reason related to him or her not having any valid exemption certificate in his or her passport. B, directed that any holder of the ZEP may not be dealt with in terms of Sections 29, 30, and 32 of the Immigration Act solely for the reasons that they are holder of the ZEP. And C, directed that the holder of the ZEP may be allowed to enter into or depart from the Republic of South Africa in terms of Section 9 of the Act, read together with the Immigration Regulations 2014, provided that he or she complies with all other requirements for entry into and departure from the departure from the 2002. I think I'm not sure if the papers here are correct. Maybe one paper is missing, because I would assume that the sentence should read as follows, which should be the concluding, the last line. Yes, it directed that the holder of the ZEP may be allowed to enter into or depart from the Republic of South Africa in terms of Section 9 of the Act, read together with the Immigration Regulations 2014, provided that he or she complies with all other requirements for entry and departure from it. Then ends there. Then there's a continuation of a sentence, but I seem not to understand its relationship with the first part that I'm reading. It says 2002, for any reason related to him or her not having a valid exemption permit, exemption certificate in his or her passport. Be directed that any holder of the ZEP may not be dealt with in terms of Sections 29, 30, and 32 of the Immigration Act solely for the reasons that they are holder of the ZEP. And C, directed that the holder of the ZEP may be allowed to enter into or depart from the Republic of South Africa in terms of Section 9 of the Act, read together with the Immigration 2014, provided that he or she complies with all other requirements for entry into and departure from the Republic, save for reasons of not having a valid permit indicated in his or her passport. I'm sure the other sentence that I was reading, they were mixed up with pages. I just received a PFD document downloaded to my computer, and then too it says the applicants are ordered to set down the main application within 12 months from date of this order, failing which this order will lapse. The cost of this application shall be cost in the main application. That is the end of the judgment. Now, my understanding, as I'm going through, as I read the introduction of this judgment and also the order of the court, if I were to draw your attention to point number 2 of the order, it says the applicants are ordered to set down the main application within 12 months from date of this order, failing which this order will lapse. Like I indicated that I do not know what the main application is, whether is what Advocate Gabriel Shumba spoke about, the merits of the case. I'm not very sure, but it says the applicants are ordered to set down the main application. So what this judgment did was to protect, so to speak, holders of the Zimbabwe exemption permits not to be arrested, deported, and so forth. But according to this order, the main application is yet to be heard within 12 months, as I understand it. You will assist me interpreting this, but that's my understanding. So let me read again so that we have the same understanding. The comrades will assist us in terms of what is the main application. It says the applicants are ordered to set down the main application within 12 months from date of this order, failing which this order will lapse. I've already given you the applicants. Yeah, that is the Zimbabwe Immigration Federation. They are the second respondent, and one of their members, who is the first applicant. I'm scrolling up to get the name of the first applicant. So you have been following the court case. Share your views in the comment section. The first applicant is Vinderen Manganzire. As I said, we have not received the judgment in the case brought by African Amenities, represented by Advocate Simba Chitando. When the court case started, we did indicate that as the Zimbabwe community in South Africa and the African Diaspora Forum, we are not part of the court case, and it's documented, or it's in the videos, is there. We said we will not claim victory for what we're not part of. I saw some comments is insinuating that we want to take credit of the judgment. We were not part of the court case, and we did promise that we'll give reasons why we never participated in the court case, and we're certainly going to do so. We'll stick to our word. Once we've discussed all this, in the next video, in a week or so, we are going to give you the reasons why we never approached the courts and always believed that negotiations is the best. So when we discuss this in this YouTube channel, some should not take it as if we are trying to take credit. No, we said from the word go that whatever the outcome of the case, whether the court was going to rule in favor of the holders of the ZEP or against, we will not take credit of anything, but we will give you our own reasons why we didn't think it was necessary as the Zimbabwe community in South Africa and the African Diaspora Forum to approach the courts. Please write your comment in the comment section, like this video, circulate, subscribe to this YouTube channel. If you're on TikTok, please do follow us. Otherwise, enjoy your weekend. Goodbye.